I want now to indulge my guests here in studio, and I'll start by introducing my guest on my extreme right, and that is lawyer Abdikadir Mohammed. He's also the President's legal advisor. Thank you very much for your time. We also have Nelson Harvey, who is also a lawyer. We were with you yesterday when that, the full verdict began, and of course I saw that you were really following through with what was happening. All right, gentlemen. So first things first, I'd like to get an assessment from you, starting with you, Abdikadir, of the whole full verdict that was given yesterday. Let's begin with what the majority had to say about the reasons they gave for nullifying the election.
Disappointed. Obviously, this is constitutional processes taking place, and that is as it should be. You have an election, you have a petition to nullify the election, and you have the reasons now. The decision and then the reasons for the. But the long and short of it is that I was hoping personally, even at a professional level, to see the reason why our Supreme Court took such a drastic, unprecedented step, and hoping that in their reasoning, there would be something I would respect. I would say, okay, I might not agree with it, but there is something there.
All right.
Absolutely nothing.
So according to you, there was nothing that met the threshold to nullify the election?
If anything, the Supreme Court has completely dislodged the standards for a good election that have been set not only in this country, but in most modern jurisdictions. It's really a very shocking decision. And you would expect that our Supreme Court would have very, very good reasons for doing that. See, what the Supreme Court said was they were not happy with the answers they got from the IEBC. That is fine. In fact, DCJ Mwilu said, when we asked you to open your servers, if you didn't open them, what were you hiding? Good question. I have no problem with that presumption.
Right.
I have a problem with the next 2-3 questions that follow. You were hiding something because you were unable to prove to us. That's the first problem. It is not up to the IEBC to prove to them. It is up to the person who is alleging to prove to them. Number two, assuming even that that's true, that the IEBC failed to prove to them. Therefore, that actually the elections were not properly held. Again, that's a completely different... The fact that the IEBC didn't open the servers is completely different from the IEBC didn't hold a proper election, is completely different from the elections were to be invalidated because they were improper.
All right.
Because look at our elections. When you go to the booth, you don't press a button, you don't pull a lever, you actually go in and tear off a physical document. You actually take it yourself. You put it in a physical manual box.
Right.
They are pulled out and counted physically. Okay. And then they are entered by hand into a form. Okay. Nothing electronic about that. So the servers and the fascination with the servers really completely misses the point. So in my opinion, the Supreme Court was like a student asking himself a question that was not on the exam and giving a wrong answer to that question.
All right. Yes. Let me hear the views of Nelson Harvey. It was one that was really anticipated. Do you feel that they gave solid reasoning as to why they would really nullify a presidential election?
In my opinion, the majority decision by the Supreme Court was so simple, straightforward and clear that everybody in the streets of Nairobi or in the hamlets of Bukoma or in Mandera will be able to see the manner in which they arrived at their decision.
Right.
Why do I say so? I say so because under the Constitution, the entire election process, and in particular the election of the president, is supposed to be simple, straightforward, transparent, and verifiable. Now, if you compare the manner in which the majority arrived at its decision, they looked at the simple and straightforward issues that were supposed to be complied with by the IEBC. For instance, if the transmission was supposed to be undertaken in a particular way, and it wasn't undertaken in that particular way, and then when you are called to inquiry to enable an investigation as to what could have gone wrong, you conceal the entry point to enable that inquiry, then of necessity, a judicious decision must come to the conclusion that you are concealing something. And it must be understood that in law, you can base a final finding not only on the claims of the petitioner, but also on the reaction of the respondent. Now, we have an institution that is mandated with the oversight of the presidential election. It is supposed to have particular declarations and to comply with certain requirements before declaring the president. Now, this institution continues with a flawed transmission process, proceeds to declare the winner when forms representing about 3.5 million votes have not arrived. Then there is a big problem there. And then when you ask them, can we interrogate this from 34A up to from 34C?
Right.
What did you see? You begin to perceive a situation whereby the forms that had originally been printed by Al Ghurair are not in place. And what do we have in their stead? We have forms that are dubious, to use the words of the Deputy Chief Justice, that cannot be explained. And you see, once you've been given an opportunity to explain yourself and you cannot explain yourself, the court must, of necessity, make an adverse inference against you. Now, contrast with the reasoning of the minority. The minority took upon themselves the role of sitting on appeal of the decision by the majority. To a large extent, in fact, up to 90% of the entire reasoning criticized the decision by the majority. They didn't offer any particular reason as to why a different outcome ought to have been reached other than the majority decision.
All right. Abdikar, just coming to you, and Javi has mentioned something to do with the process.
Yes.
And like you mentioned correctly, you know, a voter goes to the ballot, takes and drops the paper or the ballot into the box, hoping that it's going to be counted, and then later on the most preferred candidate will be winning. So really, it's not about the numbers. It's not about. It is a process that you know Kenyans undertook, and that's one of the things that the DCJ Mwilu brought forward. That it's not about numbers. It's about the process. Don't you think that the process, as per the judges, was actually flawed to some extent?
So process is important. Let's not get that wrong. Process is important, but in every place, process is supposed to help substance. Process on its own is irrelevant. The process is, in fact, in the law we say process is the procedure, is the handmaiden of substance. In accounting they say substance over form. Even in your profession, you say content over form.
Right.
The content is the critical thing. So process is important, but to what end? The process should be to clarify the decision of the voter, to assist the decision of the voter. It is not in and of itself the central part. The only place in the world right now where process trumps substance is the Supreme Court of Kenya. Everywhere else in the world, everybody understands. Process is important, but it is to assist substance. The substance, look, we have come from that place where our courts used to tell us, because we don't have the procedures to give you this right, we cannot give you this right. And it used to be the norm in our courts. You would go to court for a right, and you would be told. And many lawyers, many were told, look, the Chief Justice was supposed to have done rules to help you with that particular case. Since the Chief Justice has not done the rules, you are not entitled to it. Or some civil society organization, human rights body would come to court and they would be told you have no standing, locus standi. You are right in what you're saying, but you're not the right person. Where is the right person? The right person is in jail. How is he supposed to come to the court and file when he's in jail? Or that you are supposed to have served the president physically. That was a presidential petition. You should have gone to the president to physically serve him. How would you serve a president-elect physically? How close would you come to them? That is why in our constitution we wrote, technicalities should not trump substance. We should never use technicalities to deny rights. Otherwise, what this court is telling us is that the Court of Appeal of yesteryears, which said since President Moi was not physically served by then petitioner Kibaki, he is not entitled, or his case should fail on that. Look, I have done this thing from every side. I have been a subject of an election petition. I have been a lawyer in an election petition. I have been in the legislature doing these rules and regulations. This is exactly what we are going away from. This is not the future. This is our dark past. We should not be using process as the in and all of our elections. Otherwise, how difficult will it be for me, a participant, to mess with the process So a particular returning officer or clerk doesn't sign. You are to pay. Secondly, this is a special issue. When you're dealing with election petitions, it's not a normal case. Because where are the 16 million Kenyans, whoever they voted for in this? They're not the IEBC. They're not President Uhuru or former Prime Minister Raila. They're not the lawyers. They are out there. What is their right? What is their right in all this? That is why the court needs to find out, okay, the IEBC messed in the process. Deal with them. Deal with them harshly if you have to. But it's really shocking when the Court of Appeal says we don't have sufficient information to determine that person X is liable for the mess, but we have enough confidence to completely nullify the election.
All right.
It's really damning.
And I want us to talk about that. You're saying that, ultimately it's supposed to be that decision that was made by the Kenyan, but shouldn't that be protected through all these forms that we're talking about from 34A?
Exactly,
If there are issues to do with that, ungazetted polling stations.
You are absolutely right. Now let's go to that. So what you need to confirm for yourself as a Supreme Court is indeed that right has been manipulated. How do you do that? Not by asking IBC, open your servers, they reviews therefore you go to the conclusion, but looking and seeing what next can I do. If Justice Njoki is correct, and I have no reason to believe she's not correct, the Supreme Court had that verification in its own chambers. She was able to go to the forms and find out, actually, the returning officer in Nyali signed the form. The presiding officer in X station actually did this. Look, that is what you should be doing.
All right.
The results are in the ballot boxes as we speak now. Why are you so happy to go and ask for a fresh election, but you have no issue with, finally, scrutiny is a very difficult process, but scrutiny is about the ballot papers. I used to be a scrutineer for the Law Society when I was a young lawyer, when the Law Society used to vote on ballot. And there will be errors in every election, there's no doubt about that. There will be errors, we are human. The question to ask is, because we are dealing with the rights of 16 million Kenyans, were those errors sufficient enough to overturn the decision of the majority?
All right.
If they were, go ahead. If they were not, don't go ahead. And we have a problem with this Supreme Court because they never really went into that question. They were happy with
They did not examine, that's what you're
They
saying.
were happy with the first issue that was said, look, IBC did not open the servers. We are looking at forms that are photocopied. That does not confirm that there was no election in polling station.
All right.
It just shows you that this particular IBC officer brought to you a photocopy of a form.
All right.
When you have the original or certified copy in your own possession.
Interesting. Javi, I'd like to hear your thoughts on a number of things that he's mentioned. And also the fact that one of the reasons that Njoki Ndung'u gave is that an election is supposed to be right-centric. It's supposed to be about the rights of the citizens and not really to do with all these forms that we're seeing being talked about all over the place.
I think you can see from my colleague a lamentation that a presidential election petition is a very unpleasant exercise. And I think that's an issue that is widely accepted all over the world. The resources channeled towards the presidential election, the resources channeled towards the hearing of a presidential election petition, and even the outcome is something that really should not happen as frequent as it does here in Kenya. I'll say why. You see, the person going to vote is a very simplistic person. He needs to understand in very simplistic terms how an outcome determining who the president was arrived at. And that is the reason as to why the Constitution put a very basic threshold. It is like an audit. And how do you conduct an audit? Of course, you have your books there, you have the supporting documents. So the auditor comes, he hasn't seen what you've done throughout your financial year, but he needs to be able to establish on the basis of the documents available to him that these particular financials are well provided for. And if they are not well provided for, if they cannot be supported by primary documents, then he must reject the entire accounting process that you have originated on your own and make it an audit query. And that was the function that the Supreme Court was designed to pursue. The Supreme Court does not have the luxury of undertaking a minute, detailed hearing of evidence to ascertain was this ballot properly cast, was this tally properly undertaken. The primary function of the Supreme Court is to determine whether the will of the people, and the will of the people is a very simple will. You said you're taking this particular route to reach that destination, so I'll wait for you at the end, but you take a different route.
But shouldn't that examination of the evidence brought forward be so important? Because here you are, you're nullifying a whole presidential election. It's not a simple issue. Shouldn't that examination and scrutiny be so serious, even within the Supreme Court judges?
It is supposed to be serious, and permit me to make this submission. Now, the Jubilee and President Uhuru Kenyatta have made a lot of noise that you ought to have allowed us to recount the ballots in the ballot boxes. Well, it may appear to be a very valid claim from a layman's point of view, but these individuals had very serious legal minds in court. What they ought to have done was to cross-petition and say, despite all these problems that have been raised against us by the petitioner, we are requesting the court to undertake a recount and establish for a fact that we won by this particular margin. But what did they do? In fact, contrary to what my learned senior and very good friend espouses here, they put in all technicalities to foreclose all avenues of this inquiry. And then it cannot lie in their mouth after putting all those foreclosures to now claim that, look, you ought to have allowed us to recount. And you see in the dissenting opinion by Justice Njoki Ndung'u, this argument that we ought to have recounted the ballot papers now surfaces again. And that is an argument that has found a lot of comfort on the part of the Jubilee, only after the determination has been made, but not before.
So Betty, I think you asked a very important question. And really, this is not about lawyers. It's not even about the court. It's about we as a country and the citizens of this country. You see, we are members of political parties, but we are also fathers, we are parents, we are citizens, we are business people, and we want to move on with our lives. Life is not just about politics. We really want to move on with our lives. What we need we have the most expensive elections in the world. Bar none. And the most expensive per capita elections in the world. We have, contrary to what the Supreme Court is saying, not a simple election. We have a very complicated electoral process. The Supreme Court talked about process. Yes, but they just dealt with one very small slice of that process. We didn't hear about demarcation of boundaries. We didn't hear about registration. We didn't hear about we heard about electronic transmission of the vote. Now, if we have made it so complex to confirm, yet we have Kenyans who come to every time dispute, what do you do? I mean, we have invested so much in mistrust and ensuring that my colleague here is the watchman, I am going to watch over him, and I need a whole lot of technology to watch over me. Life doesn't go like that. You know, you go to hospital and you give your kid to a doctor, you don't ask him, can you show me your certificates? How have you been qualified? You send your money to a bank account. You never ask the bank, let me verify your ICT systems. Life has to have certain minimum basics of. So I think first, we as a country must step back. And instead of focusing on how do you catch everybody stealing, assume things are okay in the first place. Because that's the way life is. Number two, as we go forward now, we have a couple of weeks to the election. Are we going to focus on how we are going to make it extremely difficult for the IEBC, or are you going to assist the country in getting a proper election? If you have benefited from putting roadblocks, if you have been benefited from putting 100 plus cases to the IEBC barely months before the election, if you have benefited from a court saying 35 days to the election, that forget about the way you used to transmit elections. You know, Isaac Hassan, my friend, was a returning officer at the national level. He used to release things called provisional results, which was the results declared at the polling station, at the constituency level, would come to him. They're actually the results as far as the constituency is concerned, because you've already declared an MP and but he would call them provisional until he verifies and calculates and releases the election. Now, the Maina Kiai court said, you know, you steal things at that point. So stop doing that process. We want the elections to be determined at the polling station and that to be final. It's at 5 days to the election. What does the Electoral Commission do? Okay, they now drop down the priority of bombers.
Right.
They focus on the polling stations. And now the Supreme Court says, why did you deprioritize bombers? You should have brought all those documents. Because previously, the returning officers used to come with their briefcases and come to finally, Betty, if this election was handled in such a terrible manner that it was completely unlawful, how come my friend Otieno Amolo, my friend Senator James Orengo, my friend Amos Wako are all sitting there, senators and members of parliament, courtesy of the same IEBC process that they are happily castigating? You know, it's a very cruel joke to the IEBC that here are people who are sitting in office, sworn in and earning salaries because of a process you conducted, and at the same time saying that process was such terrible mess that we should actually throw the baby with the bathwater.
Javier, I want you to respond to that, because it's an argument that we've had, many, many times. Why aren't we having, a whole overhaul of this whole August 8th election if this presidential one was so bad as, one of the judges described it as dubious, actually?
Let me deal with the issue raised by the president's advisors sequentially. Now, the most terrifying statement in English is this: I am the government and I've come here to help. Ronald Reagan. Why do I say so? My learned colleague has said that we need to have trust with government institutions so that we're able to move. Otherwise, we'll be brought down by this continuous wheel that is always being slow punctured, that is called the election. That is a fallacy. The truth of the matter is that nobody trusts government, let alone any institution that is affiliated to the government. And without any fear of contradiction, I can tell you, IBC...
And the Supreme Court is, by the way, an institution of government also.
It is. IBC is an independent commission, but it's no longer in the realm of conjecture that the entire secretariat of the IBC has been infiltrated to a large extent by the Jubilee administration.
Said by who?
But how
where did we hear that?
Yeah, that's what I've said. Yeah. And this is what is said by many people outside there, and we have seen it.
But
look,
I would ask,
listen, Mheshimiwa, we saw your chief agent, just a minute. We saw your chief agent, Davis Chirchir, accessing the server, making alteration on the KIBS. It is well documented in the report submitted in the court. But permit me to close, because we must progress this discussion. The point is this: we do not have an election petition challenging the election of Senator James Orengo in any court in the land. We do not have an election petition challenging the election of Senator Amos Wako. So that cannot be an analogy. But over and above that, we have about 339 election petitions pending in the Republic right now. About 34 of them out of 47 represent election petitions challenging the election of certain governors. So it cannot be a valid argument to say that this narrative of impropriety is only limited to the presidential election.
Allow me to tell you why it is.
Let me finish. You see, the problem with you Jubilee guys, you always propagate a lot of noise. You don't want other people to speak.
Okay. I am actually surprised that these young lawyers, look at Orengo in court. He will tell you everything he wants to tell you in a manner that is really... So don't worry, state your point. You don't have to go to you Jubilee guys or XYZ. Bottom line is, if I was honestly of the view that the elections were so terrible, to the point I am the lead counsel for, I would not live with myself to go ahead and say, actually, the elections in my place were done well. These are the ones that are wrong.
But you see, Mheshimiwa, the fact of the matter is there is no challenge to those individuals we are pointing out. And I've pointed to you about 80% of these elective offices where you individuals claim to have a majority have been challenged. And in particular, the areas where there was this consistent margin of 11% between the lead candidate and the second candidate. So it goes without saying that the entire electoral process, to a large extent, in particular in areas where the general public opinion is, IBC compromised the election in favor of Jubilee, is one that is facing a big challenge.
All right, response to that, and then we move forward.
You can't have your cake and eat it. The elections are at the ward level. We have 99% of ward representatives, MCS, not challenged in court. There are less than 140 or 140 plus election petitions against MCS. Less than 1% of... Does that therefore equate to the fact that it is absolutely okay? Not necessarily. The same is true the other way around. The fact that you haven't been challenged doesn't mean the elections went well. But here you are, You are the one who has made the assertion that these elections were so terrible, we should not base the presidential elections on these elections. There was no election as far as... Now, the presidential elections come from Senator Orengo's constituency. There are votes that are coming from Senator Orengo's constituency and Senator Wako's constituency and the other lawyers who are in court. Majority of the MPs, the lawyers for the petitioner were members of parliament, both Senate and the National Assembly. So you cannot really have your cake and eat it. It's either bad or it is not. If it is bad, it's bad for you and for everybody. If it's good for you, then it's good for the other. But really, the petition for the presidential election, in my opinion, should have stood or fallen on the evidence. When you say there was an 11%, was that proved? Zero. There was no evidence led towards that. Remember Raila Odinga saying, I led by 2 million votes? Where was the evidence to prove that? Where was the evidence to prove that? You see, allegations are important, but the allegations remain allegations until a neutral party hears the evidence and concludes that actually I have had this evidence and you're right. What the court said is you have made allegations, IEBC, open your servers, show us the forms. Oh, these forms are photocopies, you have not helped us open the server, therefore, we agree with this good gentleman. The question is, where is the evidence for you to agree with? Number one. Number two, is that what the law says? Is that what the standards for an election petition are? What happens to the millions of Kenyans who voted, whose decision was important? Not the candidate, but the millions of Kenyans.
All right, Javi, I'd like you to respond to that, and also respond to a statement that was made by Ojwang, and he said that the 4 judges who were the majority made an emotional kind of ruling, and it was not based on anything under the law.
Now, first, let me debunk this myth that if the presidential election is flawed, then the entire election with the officers, five officers below the tie of the president is also flawed. Now, the flaw upon which the presidential election was annulled is simple. In this contest, the issue was in respect to the transmission. The election was conducted in each and every individual polling station. Now, under the law, the results were to be transmitted sequentially from the polling station to the constituency tallying center and at the same time to the national tallying center, so that by the time the presidential returning officer had the final tally of the results, he will be able to check what has come from the polling station and what has come from the constituency, and therefore tabulate and make a declaration. But what happened is that the IBC countermanded the process set out by the Constitution and, as affirmed in the Maina Kiai case, decided to disregard what could have been the results emanating from the polling station. Now, look at the election of Member of Parliament. Let's take, for example, I'll take the best of the examples, my friend, the Member of Parliament for Mathare, Anthony Olwach. His entire election was determined at the constituency level. So there was no opportunity of manipulation at the National Tallying Center, which was the case for the presidential election. So that should rest the matter once and for all.
Right.
Now, the second issue, my good teacher, Professor J.B. Ojwang, espoused a very eloquent theory that the decision of the majority was based on political and emotional considerations. Yes. That may well be so, but it must be understood an election process is not only a political exercise, it is a legal exercise. So that in interrogating the bona fides of how an outcome was arrived at in declaring the winner, the political process must also be interrogated. Now, how did the majority deal with this issue? They went to the strict provision of the law that required that the transmission be undertaken in this process, the declaration be made in this particular process. Now, when it was not done in the manner in which it is required by the law, the court gave an invitation to the IEBC, which has all the documents, the oversight information, so that it could be brought forward for audit. IEBC refused to give an audit. Now, in law, the conclusion is if you don't enable the court to determine an issue when the burden has shifted from the petitioner to you, then it means the petitioner has proved his case, but please, has proved his case to the standard required. And then if you look at it from that particular point of view, it becomes quite clear that the majority interrogated both the politics and the law. And you cannot dislodge politics from a legal determination relating to an elective exercise.
All right.
The two are inseparable.
All right, just a response very quickly before we take a break.
So let me tell you why my good friend is completely wrong. You see, the burden is on he who alleges. If I say that his coat is white, it's for me to prove that the coat he's wearing right now is white. Now, assuming you're the judge...
What if you're colorblind and white looks like grey to you?
Let me finish. So assuming then you are the judge, and I say, Judge, he's wearing a white coat. I am supposed to prove to you that he's wearing a white coat. If I take you to the point where you say, actually, you have made a point, it's then up to him to respond to me and show you why I'm wrong. But I have to, first of all... So NASA came and said, you have done A, B, C, D. What they were supposed to have done is prove their case. The Supreme Court didn't wait for them to prove their case. The Supreme Court turned to IEBC and said, these allegations that are being told, can you prove that they are completely wrong? IEBC fumbled. Then the court went to the second level and said, okay, we actually agree with the first guy. So let me ask you a question. The reason why you cannot decouple the MCA's elections, the MP's elections, is they are all in the same set. When you go to the ballot box, the polling station, it's one polling station. When you go to the MCA's tallying center or the MP's tallying center, that is where the presidential tallying center is for that particular constituency. Now, ask yourself this. We are sitting in a tallying center. It's a very, very focused center. People are not joking around there. You actually count one after the other. You're all sitting around. You verify there. It's not something theoretical. Everybody is watching. You verify and you sign. And if you refuse to sign, the presiding officer must, or returning officer must say, I asked Agent X to sign. He refused because of the following reasons. Now, that was all done. So verification was done, counting was done, tallying was done, and the court said, do it at the point of the polling station. Don't bring it to Nairobi because you usually steal between Nairobi and that place. That has happened. So here we are now, the Supreme Court, if it actually wanted to find out whether this happened, Nyali's results are not very far. The returning officer for Nyali is around. The person who was elected from Nyali is around. The governor of Mombasa is around. Surely, which one is easier, to verify that or to call for a new election? So here you are, you then jump the gun and say, okay, let's redo this thing. And more importantly, you say, if you again do this, we'll go back to the same position. That's why... there you go. So that is a political statement. And it's really beneath the Supreme Court to behave in that manner. Because really, the Supreme Court is the apex of our law.
Right.
My good friend here and I are lawyers. We take the Supreme Court with a lot of deference. We expect them to hold that standard.
All right.